Supplemented Delhi, item number 1.
So he's sole appellant.
Right, report has been received from Superintendent of Police on Go, dated 20/11/2025, wherein it is mentioned that the appellant died on 16/10/2021. No application has been filed. Usually for those near relatives, abets. Next.
Item 2.
Plus is required by the court that in 99 their available is not known. So the jail superintendent intimated that they are residing at Thoriasi under Kotak Mangalore jurisdiction. But report came.
Since 1999, he is not heard of. What is the mode of inquiry?
That local people have
both of them belong to Thoriasi.
Thoriasi, but their house, they are maid servants, so working as a maid servant. They are not the permanent inhabitant.
So both are alive now.
That report at present their whereabouts is not known. On verification local gentry, no one could able to give their present whereabouts. In the second page, some of the two persons have signed of locality. On previous reports,
that means the report of the Superintendent District Jail Khordha is not correct.
No, Khordha said they are not confined jail, but they are resident of Thoriasi. They are resident of Thoriasi.
So according to jail,
therefore thereafter the report
they have mentioned criminal appeal memo. It is mentioned that they are the husband and wife. And their address is at Thoriasi, Mangalaba, Cuttack.
Yeah.
And come to the LCR, let us see. Final form. Same address it is given.
Yes. As very description of the
other's name has been given. So
for the description as the maid servant, working as a maid servant.
Where?
In Thoriasi there. The present accused for one is the maid servant working in the house of the deceased. In absence of that, he has both the husband and wife enter into the house and kill the wife of the informant, took away the gold ornament. This is the.
No, that's all right, but
even the address they have disclosed in their statement, that is also the same. But how do you say how this report has come that they are not heard of since 1998, 1999, and this accused statement has been recorded on
after 2001.
In 2003.
Now this report, that's why today was 2001 the GST case. 2003
they were granted, you see, they were taken into custody and they faced the trial, they got convicted, right. Then they were released on bail. One was released on bail, that lady in 2007, and her husband was released on bail 2008. Right. So till that day they were in custody, means obviously circle jail Chaudhar. So how, because it was a Cuttack case, no?
No. Bhubaneswar. Bhubaneswar.
So either maybe Jharpada or Cuttack jail, whatever it may be, but how does that IAC said that it is not known since 1999?
It will come next week. That today I will call him for to discuss about this.
No, we'll call for a report from DCP. Let me discuss.
the two appellants, Lipi alias Draupadi Nayak and Bagho Nayak, are the husband and wife, and they face trial in the Court of London Additional Session Judge Bhubaneswar in ST case number 18/23 of 2001, and by judgment and order dated 21/2/2003, they were found guilty under section 302 and 381 of the Indian Penal Code and sentenced to RI for life, to pay fine of rupees 1,000, in default to undergo RI for 6 months under section 302, and to undergo RI for 3 years and to pay a fine of rupees 1,000 in default to undergo RI for 6 months under section 381 of IPC, and the substantive sentences were directed to run concurrently. This case arises out of Chandrasekharpur PS case number 25 of 1998. And the first information report was lodged on 17/2/1998 by Narayan Mishra. The final form was submitted on 15/10/1999, which shows that both of them were arrested and forwarded, arrested on 19/7/99. Both of them, after their arrest, were forwarded to on 27/1999. And during trial, they were not released on bail. However, during pendency of this appeal, the appellant number 1, Lipi alias Draupadi Nayak, was directed to be released on bail by order dated 2/5/2007, and appellant number 2, Bagho Nayak, was directed to be released on bail by order dated 26/2008. Not only in the final form, but also in the accused statement. Where is that accused statement? But also in the appeal memo, the address has been mentioned as Puriya Sahi, PS Mangalabag, Dist Cutter. As per the order dated 18/11/2025, we asked the Learning Council for the state to obtain instruction regarding the well-being of both the appellants. Today, the Land Council for the state has produced written instruction dated 25/11/2025 from IIC Mangalabag Police Station, wherein it is mentioned that since 1999, both the appellants were not residing at Surya side. and at present their whereabouts is not known, and on verification from local gentry, no one could able to give their present whereabouts. We are not satisfied with the report furnished before us by the IIC Mangalabad police station. Therefore, let the DCP Cutter inquire into the matter and submit a report to this court by 5th of December 2025 regarding the well-being and whereabouts of both the appellants. Free copy of the order be handed over to the Land Council for the state, which will be communicated to the DCP concerned. Matter will be stated on 9th of December 2025. The Land Council for the state shall produce the report of the DCP on the next date. Yes.
Item 3.
Legal collect the same.
Whereabouts not known.
The Sarpanch has intimated such Sarpanch put as follows. The appellant is missing from the village since long, but he has not returned to his village. He may be alive, as no one has got his death claim.
Superintendent of Police. The appellant Sahoo Hon'Ble alias Bangra has preferred this appeal as he was found guilty by the Leaden Ad hoc Additional Session Judge Fast Track Court Baripada in Sessions Trial Number such and such, which arises out of so and so PS case number in for offense punishable under section 302 and 324. 307, conviction is 324. 302 and 324 of the Indian Penal Code, and sentenced to imprisonment for life and to pay fine of rupees 2,000 in default to undergo further RI for 1 year under section 302 IPC and RI for 1 year under section 324 of the Indian Penal Code, and both the sentences were directed to run concurrently. Trial court record this case arises out of Betonoti PS case number 29 dated 33/2002. The final form submitted in that case indicates that the petitioner was taken into judicial custody on 16/4/2002, and during trial he was not released on bail, and during pendency of the appeal he was granted bail by this court by the order dated 21/2010. Stop. When the matter was taken up on 25/11/2025, a written report dated 16/8/2025 was produced before us from Inspector in charge of Betanoti Police Station, wherein it is indicated that during inquiry it was found that the appellant was missing from the village since long and his whereabouts is not known. Since in that report there is no mention as to whether any family members, neighbors, friends, public relatives of the appellant were asked to ascertain the whereabouts of the appellant, we asked the London Council for the state to obtain the well-being report. In the report, which is the Land Council for the state has produced a report from dated for them to 27/11/2025 of IIC Bethnodi Police Station, wherein it is mentioned that during his inquiry at village, along with Sarpanch Bethanoti, it was ascertained that the appellant was missing from his village since long, and he has not returned to the village, and he might be alive. No one has got death news. The report which is submitted today also doesn't indicate, as per our previous order dated 25/11/2025, whether inquiry has been made from the family members, neighbors, friends, and relatives of the appellant. Therefore, this report is not in consonance with the order dated 25/11/2025, even though the certificate issued by the Sarpanch has been annexed to the report. Therefore, we direct the Superintendent of Police, which is Mayurbhanj, to inquire into the matter and submit a report by 5th of December 2025 regarding the well-being and whereabouts of the appellant. Matter will be listed on 9th December 2025. Free copy of the order, so and so.
You are appearing for it?
Yes, my lord.
What is your information?
My lord, I have not yet received any information from the appellant, my lord. Because since long he's not in contact.
So that means there is no instruction. Then how you are appearing?
My lord, since my name is appearing and
Oh,
I have
because
tried
your
to
name
contact
is there.
I have tried to contact the appellant through the lower court advocate, but I could not able.
You see, it is a regular criminal appeal.
Yes, sir.
You should have, it is not a jail criminal appeal that we will ask the, it is a thing that you are to conduct the case, and
Yes,
you
sir.
should bring all these materials before us.
Yes, sir.
The whereabouts, the well-being, all these things. But you say there is no information.
I'll take it.
No, if you say that you have no instruction, that means we have to engage a lawyer from the panel. Why should we wait for you?
But my lord, I have tried to contact, but I have failed to obtain the instruction. For that reason, I submitted.
No, why without instruction you will argue this matter? Suppose at that point of time he has given you instruction to appear and you file wakalatnama. Now there is no instruction. So why you just file a memo and somebody, if after that, if you do want to do the pro bono service, the matter is different. Otherwise, why the regular appeal you should? We are fixing it to 9th. You do the needful. Yes, next.
Item 4.
I don't familiar.
Yes.
My lord. On that basis, my lord, the FIR has been lodged, and now yesterday that activity has been recaptured. So yesterday that activity has been recaptured, that convict. I am also.
He has been apprehended.
Apprehended and recaptured yesterday. Is the present in the court also. So on the BC. Court has.
এই ତାକୁ ସାମ୍ନାକୁ ଆଣ ମଙ୍ଗୁ
सर नमस्कार सर मंगलू राउत प्रेजेंट अछन सर
ହଁ ତାକୁ ସାମ୍ନାକୁ ଆଣନ୍ତୁ ଆମେ ପଚାରିବୁ ତାଙ୍କୁ ମଙ୍ଗୁଳ ରାଉତ ତମ ଘର କୋଉଠି
ତରକେରା ଅଟେ
ଆଁ
ତରକେରା
ଦରକେରା କୋଉ ଜିଲ୍ଲା
ସୁନ୍ଦରଗଡ଼
ସୁନ୍ଦରଗଡ଼ ଜିଲ୍ଲା
ହଁ
ଇଏ ତମେ ଏଇ ଯୋଉ ହାଇକୋର୍ଟରେ ଯୋଉ କ୍ରିମିନାଲ ଅପିଲ ଟା ଦାଖଲ କରିଥିଲ ଯୋଉ ଜଜ୍ କୋର୍ଟରେ ଯେହେତୁ 302 ଦଫାରେ 28 ଜାନୁଆରୀ 2005 ରେ ହେଲା ତମକୁ ଆଜୀବନ କାରାଦଣ୍ଡ ଆଦେଶ ହେଇଥିଲା ସେଇଥିପାଇଁ ଅପିଲ ଟା ଦାଖଲ କରିଥିଲ ଅପିଲରେ ତମକୁ 13/10 ଅପିଲରେ ତମକୁ ତମର ବେଲ ରିଜେକ୍ଟ ହେଲା ପରେ ଯାହା ଆମେ ଖବର ପାଇଲୁ ତମେ 26/6/2007 ରେ ମାସେ ପାଇଁ ତମେ ଥିଲ ପ୍ୟାରୋଲରେ ତାପରେ ଆଉ କୋର୍ଟରେ ଆଉ ଜେଲକୁ ଫେରିଲନି କୋଉଠି ରହୁଥିଲ
ଘରେ ଥିଲି ବାହାରେ ଯାଇଥିଲି
ଘରେ ଥିଲ ତ
ହଁ ଘର ଅସୁବିଧା ଟିକେ ଥିଲା
ଘରେ କଣ କରୁଥିଲ
ସେଠି ଲେବର କାମ କରୁ
ଲେବର କାମ କରୁଥିଲ ଆଉ ତମକୁ ପୋଲିସ କଣ ପାଉନଥିଲେ ଯେତେବେଳେ ତମେ ନ ଫେରିଲ ପ୍ୟାରୋଲରେ ଯାଇକିନି ମାସେ ପରେ ପୋଲିସ କହୁଛନ୍ତି ଆମେ ପାଇଲୁନି ବହୁତ କମ୍ପିଟେଣ୍ଟ ପୋଲିସ ଅଫିସର ଗୁଡାକ 2007 ମସିହାରୁ ତମେ ପ୍ୟାରୋଲରେ ଯାଇ ଗାଁରେ ଥାଇ କାମ କରୁଛ ମାସକ ପାଇଁ ଯାଇ ଆଉ ଫେରିଲନି ଜେଲକୁ ଆଉ ସେମାନେ ପାଇଲେନି କେମିତି ଗୋଟେ ଫାଷ୍ଟ ଇନଫର୍ମେସନ ରିପୋର୍ଟ ଲଜ୍ ହେଲା ରାଜଗାଙ୍ଗପୁର ଥାନାରେ ରାଜଗାଙ୍ଗପୁର ଥାନା ମଧ୍ୟ ପାଇଲାନି ତମକୁ ଗାଁରେ ଥିଲ ତ ଆଚ୍ଛା
କାମ କରୁଛୁ
କାମ କରୁଥିଲ ଘରେ କିଏ ସବୁ ଅଛନ୍ତି ଘରେ କିଏ ସବୁ ଅଛନ୍ତି
ଛୋଟ ଛୁଆ ମାନେ ବିବି ଅଛନ୍ତି
କେବେ ଆସିଛନ୍ତି ରାଜଗାଙ୍ଗପୁର ଥାନାରୁ ତମ ଘରୁ କେବେ ତମକୁ କିଛି ପଚରା ପଚରି ଖୋଜାଖୋଜି କରିବାକୁ ଆସିଛନ୍ତି
ଆସିନି
ପୋଲିସ କେବେ ଯାଇଥିଲେ କି ତମ ଘରକୁ ଯାଇଥିଲେ କଣ କହିଲେ
କହିଲେ
ତମ ସାଙ୍ଗରେ ଦେଖା ହେଇଥିଲା କି ନାଇଁ ପୋଲିସ ବାବୁର
କହିଲେ ୱାରେଣ୍ଟ ବିଷୟରେ
କଣ ଦେଖୁଛ
ସିଆଡେ କୁଆଡେ ଯାଉଛ ୱାରେଣ୍ଟ ବିଷୟରେ କହିଲେ କହିଲେ ୱାରେଣ୍ଟ ହେଇଛି ଆଜ୍ଞା ଯେତେବେଳେ ସୁବିଧା ହବ ଆସିବେ ଆଚ୍ଛା
Mr. Superintendent, who else is there who is looking at him?
सर
Who else is there?
सर जमादार सर हेड कांस्टेबल सर चीफ वार्डर
ତାକୁ କହିଛ କି ତମ ଯାହା ପଚାରିବେ ମୋ ମୁଣ୍ଡ ଟୁଙ୍ଗାରିବି ମୋ ଆଡକୁ ଅନେଇବ why is looking after towards you
So how is that you filed the FIR since long and it is only after the intervention of this court in 2025 he could be nabbed? So for all these years the police didn't try even to see that the convict who has gone on furlough or parole is absconding
available
for 20 years.
Available in the village and they have also communicated that warrant has been but no arrest has been made Strange.
Has he sent the copy of the FIR?
Yes, FIR copy, and earlier the 2007, and they are also sent the.
अरे जो आपण बार निजे कहले एफआईआर ହେଇची जो हेरिलानी बेली राजगांवपुर पुलिस स्टेशन
FIR copy.
दियो
All the report is here. 2007 ରେ ସେମାନେ ୱାରେଣ୍ଟ କଲେ ଏବେ FIR କରିଛନ୍ତି।
ओहो
So it is only after the court passed an order that they have. Very, very small. Definitely. So good.
So Lepicini released on parole leave for a period of so and so, and he was instructed to surrender himself before the jail on so and so. The convict has not surrendered on 27/2007 district jail, not recaptured till date. तापरे इतला ହେଇଛି କେବେ ନା 2025 let him give a
including the
take down.
Could you follow, Mr. Naik, what has happened? It is only after the order was passed by this court, they have filed an FIR. Until these 20 years, he was absconding and there were no step was taken by.
No, yesterday he made he appeared in that DG presence and he told us that there is in the parole more than 100 persons from different jails.
66.
They have gone on parole or prolong, whatever it may be.
66.
They have
66.
66.
I think it is from that
Jamujari.
32 Jamujari and others are 30.
What about we said that about 100 more than
That is the for filing of the cases. More than appeal.
So more than 60 cases this thing has happened.
And FIR lodged before the Chandaka police station, they did not accept the FIR, some of the cases.
All right, take down. The as per the order dated 25/11/2025, the Learned Counsel for the state has produced the report from the Superintendent District Jail Sundargarh, which indicates that the appellant Mongolu Raut was released on parole leave for a period of 30 days with effect from 27/2007 to 26/7/2007 as per Prisons Directorate letter number 1002 dated 16/6/2007, and he was instructed to surrender himself before the jail on 27/7/2007. However, the appellant didn't surrender at District Jail Sundargarh nor recaptured till date. Report dated 24/11/2005. In the said report, one FIR has been annexed, which was lodged before the IHC Rajgangpur Police Station, Sundargarh, on 25/11/2025.
24 was and 25 is the stationary entry on 25.
FIR तो लॉज ହେଇଛି 25/11/2025 25/11/2025, for which Rajgangpur PS case number 624 of 2025 was registered under section 224 of the IPC. Stop. Another report dated 26/11/2025 has also been submitted by the Superintendent District Jail Sundargarh, wherein it is mentioned that after the parole leave for 30 days, when the appellant did not surrender, on 27/7/2007, a wireless message was sent to IIC Rajgangpur police station on 28/7/2007 regarding the non-surrender of the appellant, and request was made to take necessary step to recapture him. It is further mentioned that Dharmendra Kumar Naik, CCT of district jail, CCT mane kon?
Clerk cum typist, sir.
Huh?
Clerk cum typist.
अरे मैं unmute करा दूं?
CCD का what is CCD?
What is CCT?
Sir, clerk cum typist.
अच्छा, clerk cum typist of district jail Sundargarh was deputed to the village of the appellant to contact the family members of the appellant.
CCT is that.
On 2/8/2007, the Superintendent District Jail Sundargarh requested IIC Town Police Station Sundargarh to file an FIR regarding non-surrender of the appellant and to recapture him. Again on 14/8/2007, another wireless message was sent to IIC Rajgangpur Police Station to inform regarding the steps taken to recapture the appellant. And then on 24/11/2015, a letter was sent to IIC Rajgangpur Police Station to recapture the convict, and accordingly an FIR was registered on 25/11/2025. हाँ 25/11/2025 stop. On 24/11/2025, the Superintendent District Jail Sundargarh also requested the London Trial Court to take necessary steps as per law to recapture the appellant. Stop. Yeah. In another letter dated 26/11/2025, it has been mentioned that the appellant was recaptured on 26/11/2025, was absconding since 27/6/2007 till 25/11/2025 after availing parole leave. Stop. The reports are taken on record. The jail superintendent Sundargarh ensured the appearance of the appellant Mangulu Raut through virtual mode. When we made a query to the appellant as to after being released on parole leave, where he was staying and what was his avocation, he stated that he was staying in his village, Torkora, under Rajgangpur police station in the district of Sundargarh with his family, and he was doing labor work. Stop. When we made a further query as to whether at any point of time Rajgangpur police approached him in connection with the case, the answer was also in affirmative, and it was told to us that he was intimated by the police that warrant has been issued against him. Stop. the entire scenario shows that after being released on parole for 1 month, for 30 days, the appellant was all along available in the village. As per his statement, he was staying with his family and doing labor work. And even though intimations have been sent from the jail authorities to the IIC Ranjanpur police station regarding non-surrender of the appellant, and request was made to recapture him, but the same has not been done. Ultimately, when the court in criminal appeals, in which similar things have happened, drew the attention of this thing to the DG of police, it seems that the first information report was lost only on 25/11/2025, and the appellant was recaptured on the very next day, that is on 26/11/2025. This is a sheer negligence on the part of the police authorities in not apprehending, not taking effective steps to apprehend, to recapture the appellant who was all along available in the village. Let an inquiry be conducted by the DG presence on this aspect as to who was responsible for, or who was in laches for non-apprehension or non-capture of the non-apprehension of the appellant for about for more than 18 years. Stop. The necessary step taken against if the laches is found out, this court expects that appropriate action shall be taken against the erring officials with intimation to this court. List this matter. We are giving you 4 weeks time to inquire, a detailed inquiry into the matter, and submit a report. Can take up it
one thing
December.
Sir, one thing make clear that once it's 30 days not returned, jail authority has intimated police station.
Why should we make this? Why should we go for this inquiry? Let the DG present take it. It is none of our duty.
You see, it may be a number of IIC who have been posted in that particular police station during that particular period. But from this documents, it appears that 2 intimations have only gone to that Rajgangpur police station. And the last intimation, which was a wireless message, that was sent on 14/8/2007, and thereafter in November 2025. So for more than 18 years, there was no correspondence
from jail to the
from
police.
jail to police
That's
station.
the 30 days not in the jail authority should have intimated not returned.
Let them do it. Let the jail authority say. Can't we know that it's an IOS? Absolutely an IOS. The moment we reacted in the order, an FIR has been filed. On 24th, he is making a information to the police station. So it is all the district jail. We know it.
You are
Let us
allowing
see.
this casual approach And he's
For
not
18 years.
he's not that type of man who can influence the police agency. The poor man doing labor work. So it's a sheer negligence. It's not that he can put an extraneous pressure to somebody so that he will not be recaptured. He's a labor. He's available in the village with the family. And you are what he has stated that the police has come and intimated that warrant has been issued against you. That's all. Yes, next. Rocky 23 December. 3 copy of the order be handed over. And what about Mongulu Raut?
ମଙ୍ଗଲୁ ରାଉତ ଶୁଣି ପାରୁଛ?
ହଁ ଆଜ୍ଞା।
ତମ ତରଫରୁ ତମେ ଓକିଲ ବାବୁ ଦେଇଛ ନା ତମକୁ ସାହାଯ୍ୟ କରିବା ପାଇଁ ଓକିଲ ଆମେ ସରକାରୀ ସାହାଯ୍ୟ ପ୍ରାପ୍ତ ଓକିଲ ଦବାକୁ ତମେ ଚାହିଁବ? ତମ ତରଫରୁ ତମ ପଇସା ନିଜେ ଖର୍ଚ୍ଚ କରି ଓକିଲ ବାବୁ ଲଗେଇବ ଏଠି କେସ୍ ଶୁଣାଣି ପାଇଁ ନା ଆମେ ସରକାରୀ ସାହାଯ୍ୟ ପ୍ରାପ୍ତ ଓକିଲ ଦେବୁ?
ହଁ ଆଜ୍ଞା
ତମେ
ସାର୍।
ଯୋଉ ଓକିଲ ବାବୁଙ୍କୁ ଏଠି ରଖିଥିଲ ଯୋଗେନ୍ଦ୍ର କୁମାର ମହାନ୍ତି ଏବେ ନାହାନ୍ତି।
ହଁ ବହୁତ ବରଷ ହେଇଗଲା।
ଆଜ୍ଞା
ବହୁତ ବରଷ ହେଇଗଲା ଏମାନେ
ବହୁତ
କରୁଥିଲେ।
ବରଷ ହେଇଗଲାନ ଜାଣି ନାହିଁ।
ତମେ ସାର୍ ଯାହା ପଚାରିଲେ ତମେ ବର୍ତ୍ତମାନ ଆମର ଏଠି ଆଇନ ସହାୟତା କେନ୍ଦ୍ର ରହିଛି ଯୋଉଥି ବିନା ଖର୍ଚ୍ଚରେ ତମକୁ କିଛି ଖର୍ଚ୍ଚ କରିବାକୁ ପଡିବନି। ତା ଦେହରେ ଯୋଉ ଓକିଲ ବାବୁ ମାନେ ଅଛନ୍ତି ସେମାନେ ହିଁ ତମ କେସ୍ ମାଗଣାରେ ଏଠି ଆପିଲ ଶୁଣାଣି କରିପାରିବେ। ତମେ ଯଦି ରାଜି ହବ ଆମେ ତାଙ୍କ ସେଇ ପ୍ୟାନେଲରୁ ଜଣକୁ ଓକିଲ ବାବୁ ମାନଙ୍କୁ ଦବୁ ନିଯୁକ୍ତି କରିବୁ ନା ତମେ ନିଜେ କୌଣସି ଓକିଲଙ୍କୁ ଦବାକୁ ଚାହୁଁଛ ଇଏ କରିବୁ।
ସରକାରୀ ଓକିଲ କରିଦେବୁ।
ସରକାରୀ ଓକିଲ କରିଦବ? ଆଚ୍ଛା ସେ ସରକାରୀ ଓକିଲ ଆମେ ଦେଇ ସାରିଲା ପରେ ତମକୁ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କ ମାଧ୍ୟମରେ ଜଣେଇଦେବୁ ତାଙ୍କ ନାଁ କଣ, ତାଙ୍କ ସହିତ ତମେ ଯୋଗାଯୋଗ କରିପାରିବ ଏଇ ଇଏ ସଞ୍ଚାର ମାଧ୍ୟମରେ ଆଉ ତମ କେସ୍ ବିଷୟରେ ତାଙ୍କ ସହିତ ଆଲୋଚନା କରିପାରିବ ହେଲା।
So and so the Raja, when we asked, it like they were non-appears for the appellant. When you ask the appellant as to whether that since his counsel is not appearing in the court, whether you interested to engage another counsel or a counsel from the High Court Legal Services panel will be engaged so and so. He stated that let an advocate from that High Court Legal Services Authority be engaged for me. So and so is engaged. Let the registry communicate the concerned advocate about his engagement in the appeal, and the paper book shall be supplied to the land council. And if the land council wants to have interaction with the appellant, the registry shall make necessary arrangement for virtual interaction between the council and council as well as the appellant. Yes. ଆପଣଙ୍କର ଓକିଲ କିଏ ନିଯୁକ୍ତି ହେଲେ ଆଉ ଆଜିର ଯୋଉ ଆମେ ଯୋଉ ବର୍ତ୍ତମାନ ଅର୍ଡରଟା ପାସ୍ କଲୁ ଆପଣଙ୍କର ଯୋଉ ଜେଲର ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କ ପାଖକୁ ପଠା ହେଇଯିବ। ସରକାରୀ ଓକିଲ ପଠେଇଦେବେ, ସେ ଆପଣଙ୍କୁ ପଢିକିନି ବୁଝେଇଦେବେ। ତା ଦ୍ୱାରା ଆପଣ ଜାଣିପାରିବେ ସେ ଓକିଲଙ୍କର ନାଁ କଣ, ତାଙ୍କର କଣ୍ଟାକ୍ଟ ନମ୍ବର କଣ। ତାପରେ ଆପଣଙ୍କ ସାଙ୍ଗରେ ଓକିଲ ବାବୁ ଦରକାର ପଡିଲେ କେସ୍ କାଗଜ ପତ୍ର ପଢି ସାରିଲା ପରେ କଥାବାର୍ତ୍ତା ହେବେ। ତମ କେସ୍ ବିଷୟରେ ଯାହା କହିବା କଥା ତାଙ୍କୁ କହିବ ବୁଝେଇକି ହେଲା। କୌଣସି ପଇସା ଏଥିରେ ଆଉ ପଡିବ ନାହିଁ ତମ, ଠିକ ତ? ନେକ୍ସଟ
Item 5.
Item 5 that the applicant has been dead, you will file the report from the Sarpanch.
appeal memo করা এটা জেল ক্রিমিনাল appeal আছে সিঙ্গেল appellant না
Single applicant.
দুজন ଅଛନ୍ତି
ଜଣେ
ନାଇଁ ନାଇଁ ଦି ଜଣ ଟ୍ରାଏଲ ଫେସ୍ କରୁଥିଲେ ପଙ୍କଜ ଭୋଇ ଆଉ ସାନନ୍ଦ ସାହୁ କଣ ହେଲା
ତ appellant ଅଛି
ଆଉ ଆରଟା କଣ ହେଲା ମାନେ ଜଜମେଣ୍ଟ କଣ ହେଲା ଆଚ୍ଛା ସାନନ୍ଦ ସାହୁକୁ ଖଲାସ ହେଇଯାଇଛି ପଙ୍କଜ ଭୋଇକୁ କନଭିକ୍ସନ ହେଲା ଏବଂ ତାକୁ ଆଜୀବନ କାରାଦଣ୍ଡ ଠିକ ଅଛି ଆଚ୍ଛା 10/10/2025 ରେ ଡେଥ୍ ହେଲା District Court Hospital Bhubaneswar during his treatment. Application death certificate all that. This jail criminal appeal has been filed by Pankaj Bhoi, who has been found guilty under section 302, 376 and 201 of the Indian Penal Code by the Lenin Additional Session Judge Bargad in ST case number such and such and sentenced to such and such. The appellant was directed to be released on bail by order dated 8/7/2011. Today, the Land Council for the state has produced a report from Deputy Superintendent of Police in charge, Borpali Police Station, wherein it is mentioned that the appellant died on 10/10/2025. And in that connection, the letter of the Sarpanch and the application form for death certificate, etc., have been annexed to the report, which is taken on record. In view of such report, since no near relatives of so-and-so have filed any application to continue the appeal under section so-and-so, the appeal abates. What's next? And disposed of.
Item 6.
Yes, sir.
This one is alive.
June. Sole appellant. The Land Council for the state has produced the written instruction received from IIC
Pondapada PS.
Pondapada Police Station, Keonjhar, which indicates that the appellant is alive. The report is taken on record. Who is the counsel here? Chittaranjan Sahu, SR Sahu.
Chittaranjan Sahu and Associates file भी ना. Chittaranjan Sahu and Associates file भी ना.
That is what.
So I'm produced from Chittaranjan Sahu, तापर लिखा है जगह सुषमा रानी साहू. None appears for the appellant. The Land Council for the state submits that will intimate the Land Council about the listing of the matters. Since paperwork has been prepared, have you received the paperwork? The state council has received the same. If Mr. Sahu has not yet been supplied with the paperwork, the same may be supplied to him, and matter will be listed on 9th of December 2025 for hearing. Yes, next.
Item 7.
Item 7 Miller. The report from the district jail superintendent that he has sent the letter to the IIC concerned to the wherever. I pay some more time to you can collect the report from the IIC. And the district jail superintendent sent that he has been released on bail, so you can come into.
He was released on bail since 2014.
My lord. I am sending the letter after thereafter on 22/4/25 we are sending the letter.
This happened on election. The appellant has been released on bail from the jail. So ତାକୁ କାଇଁ ମଗେଇଲେ ଯିଏ ରିଲିଜ
That is we are
ତାକୁ ତାପରେ ଆଇଆଇସି କୁ ମଗେଇଥାନ୍ତେ ଯିଏ ବେଲରେ ଚାଲିଗଲାଣି ତା ଆଇଆଇସି
Jail
ଯାଇ
law
କଣ
could
ଯିଏ ଜେଲ ଆଉ ତ
that's why I am saying it for my lordship.
କିଏ କଣ ପାଇଁ ଆଇଆଇସି ତାର କଣ ଦରକାର ଲେଖିବା
It come next week. I will
ଲେଖନ୍ତୁ the appellant so and so has been released on bail as per order dated एकतीस 7/2014 ଏଇ ଚିଠିଟା ପରେ ପ୍ରଡ୍ୟୁସ କରିଥିଲେ ଲାଷ୍ଟ ଟାଇମ ପୁଣି କଣ ଏଇଟା ଗୋଟେ ପ୍ରଡ୍ୟୁସ କଲେ ଆମର ଏଇଟାକୁ ଲେଖିଛୁ ଗତ ଥର ଲେଖନ୍ତୁ when the matter was last taken up on 29/4/2025 and a report from the Superintendent District Jail Balangir was produced before us, which showed that the appellant has already been released from jail. We asked the Land Council for the state to obtain instruction regarding the well-being of the appellant. It seems nothing has been done by the Land Council for the state to ascertain the well-being of the appellant.
You have no information.
No.
ଆପଣ ଆଇଆଇସି କୁ ଚିଠି ଲେଖିନା the Land Council or the state submits that necessary instruction is to be obtained from the IIC Uthana
Saintala.
या घर ସେଇଠି ତ criminal appeal them the prisoner section ଟା ପଢ yes sir
Yes, sir. Jinky Dumiri.
PS Saintala
Jinky Dumiri. First aid.
Jinky Dunguri.
village hochi
Jinky Duguri.
PS Saintala like IIC Saintala police station है ना as the appellant belongs to village Jinky
Dunguri.
है ना under the said police station in the district of Balangir है ना put of this matter so the 8 तारीख 9 तारीख राउंड से नहीं सुनता है ना 9th of the Land Council for the petitioner Swanso is present for the petitioner for the appellant and submits that he has also no instruction regarding the variables of the appellant. 9/12/2025. Next.
Item 8.
8. From the last instruction from jail authority, we have sought for instruction from the IAC concerned. So we have not received. I prefer next week only Tuesday.
Same thing, so again. Will bail 16/8/2011. Have you written anything?
Yes. Yes. The inadvertent because the file does not reflect any order sheet. That's why mistake has been committed.
The very letter which you have sent to the IIC, that should form a part of your file. So that court can also verify it.
Tuesday.
Let me. The London Council for the state seeks some more time to obtain instruction regarding the well-being of the appellant through the IAC of Edakuthana, Dhenkanal Sadar Police Station, Sambalpur, Sambalpur Sadar Police Station. Put up this matter. Kebe running upon? Na 9 tarikh asun. 9/12/2025. Yes, next.
Item 9.
9 June. The Land Council for the state has produced the report dated 28/6/2025 of IAC Plant Site Police Station, Raurkela. We show that the appellant is alive. Yes, who is the counsel? Rakesh Kumar Mallik. And VP Mahanti P. Das. Rakesh Malik used to come to the court.
Yes, I know that Rakesh.
Whether he has collected the paper book. Paper book is ready. 2007 criminal appeal, jail criminal appeal. Look on the non-appeals for the appellant and counsel for the state submit. Ask him to collect and get ready. We are adding this matter to the hearing list. Counsel for the state submit that he will intimate Mr. Malik about the listing of the matter. Staff, you have received the paper book? Madam. The paper book has been received by the Land Council for the state. If Mr. Malik has not received the paper book copy, the registry shall hand over paper book to the Land Council and the matter be registered on 9th of December 2025 for hearing. Yes, next.
Item 10.
10 minutes. I'll leave.
He is there, Mr. Rai is ready.
Appellant, single appellant?
Single appellant.
Govinda Pujari. You have received the paper book?
No.
Yes, Mr. Rai. Paper book. Let's go. The Land Council for the state has produced the report dated 25/5/2025 of IAC Malkangiri Police Station to show that the appellant is alive. The report is taken on record. Stop. Mr. Dilip Rai, Land Council for the appellant is present. Now paper book given. Paper book घर थी पड़े पेपर बुटा नहीं पूरा आप रिसीव कर दियंतु
ना करने
नहीं पेपर बुटा में पचार कुआडे गला आपण अनुचन जेंती पेपर बु पाई नांती बरी
ना मु पेपर बु पाई
पाई जेंती कोड छाड़ दिया कोड ना तार फाइल भीतर अछि
ना ये फाइल नहीं
आउ कोड केस फाइल
एटा आउट केस
अरे पेपर बुटा आपण मैटरटा हियरिंग पे अछि पेपर बुटा केम न नहीं पळेले
आसना के रखा जी सेटा कोइ था फास्ट रू इट मे कम टुमारो
No, you can get it in our welcome.
Through I am not acquainted with this.
No, we'll get you acquainted. Yes. Anybody please help?
पढ़ापढ़ी ହେଇଛି ତ फाइल ଦେଖିଛନ୍ ତ
फाइल देखिथिली नोट करथिली सेथि नोट सब अछि विथ जजमेंट कॉपी भी अछि तो काली आसु
Are you aware that this particular bench is functioning twice a week on Tuesday and on Thursday? On other day there is a different bench. Daily paper uta dekho form case ta dekho. Extra paper will be achieved. Tamgote देगी उनको धरी. नहीं आपण एस्तेला को आसंतु.
मेल पेज 24
24 हां पढो.
मु श्रीमती सुनामणि खोला
ସୁନାମଣିଟା କେତେ ନମ୍ବର ସାକ୍ଷୀ? 4 ନମ୍ବର ସାକ୍ଷୀ। ଆଚ୍ଛା, PW4 ହଁ ରହିଗଲେ ଯେ
PW4
ହଁ
ବୟସ 50 ବର୍ଷ, ସ୍ୱାମୀ ପରଶୁରାମ ଖୋଲା, ଗ୍ରାମ ଝାଟିମାଟି କଲୋନୀ, ପଦ୍ମଗିରି ପୋଷ୍ଟ, ପଦ୍ମଗିରି ଥାନା, ଜିଲ୍ଲା ମାଲକାନଗିରି। ଆଜି 27/12/2016।
ତା ସ୍ୱାମୀ ନାଁ ହଉଛି ପରଶୁରାମ ଖୋରା, ଯିଏକି ହଉଛି ଏ କେସରେ ଡିସି। ହଁ ପଢନ୍ତୁ।
ଆଜି 27/12/2006 ବୁଧବାର ଅପରାହ୍ନ 3ଟା ସମୟରେ ମୋର ଝାଟିମାଟି କଲୋନୀ ସ୍ଥିତ ଘର ପାଖରେ ମାଲକାନଗିରି ଥାନା ପୋଲିସ ବିଭାଗରେ ଲେଖି ଜଣାଇଦେଉଛି ଯେ ଗତ 3 ବର୍ଷ ତଳେ ମୋର ସାନ ଝିଅ ବୁଧବାରୀ ମେତୱାଡା ଗ୍ରାମର ହରି ପୂଜାରୀଙ୍କ ପୁଅ ଗୋବିନ୍ଦ ସହ
ଗୋବିନ୍ଦ ମାନେ ହେଲା ଆପେଲାଣ୍ଟ ହେଲା
ଗୋବିନ୍ଦ ପୂଜାରୀ ପ୍ରେମ ବିବାହ କରିଥିଲା। ବିବାହର 6 ମାସ ପରେ ମୋର ଝିଅ ଓ ଜ୍ୱାଇଁ ମୋ ଘରେ ଆସି ଅଲଗା ରୋଷେଇ କରି ଖାଇ ରହିଲେ। ମୋର ଜ୍ୱାଇଁ ଗୋବିନ୍ଦ ପ୍ରାୟ ସମୟ ମଦ ଖାଇ ମୋ ଝିଅ ବୁଧବାରୀକୁ ମାରପିଟ କରୁଥିଲା। ମୋର ମନୁଷ ସ୍ୱାମୀ ପରଶୁରାମ ଏଥିରେ ବାରଣ କରୁଥିବାରୁ ମୋର ଜ୍ୱାଇଁ ଗୋବିନ୍ଦ ତା ସହ କଳି ଝଗଡା କରୁଥିଲା। ଆଜି ତା 27/12/2006 ବୁଧବାର ଅପରାହ୍ନ ପ୍ରାୟ 2 ଘଟିକା ସମୟରେ ମୋର ମନୁଷ ସ୍ୱାମୀ ମୋର ଘର ପିଣ୍ଡାରେ ଖାଉଥିଲା। ମୋର ଝିଅ ବୁଧବାରୀ ତାର ଘରେ କରିଥିବା ମାଛ ତରକାରୀ ତାର ବାପା ପାଇଁ ଆଣିବାରୁ ମୋର ଜ୍ୱାଇଁ ଗୋବିନ୍ଦ ଝିଅ ବୁଧବାରୀକୁ ମାରପିଟ କଲା। ଏହା ଦେଖି ମୋର ମନୁଷ ମୋର ଜ୍ୱାଇଁ ଗୋବିନ୍ଦକୁ ଗାଳି କରିଲା। ଏଥିରେ ମୋର ଜ୍ୱାଇଁ ଗୋବିନ୍ଦ ରିସା ହୋଇ ମୋ ଘରୁ ଏକ ଟାଙ୍ଗିଆ ଆଣି ମୋର ମନୁଷକୁ ପରଶୁରାମକୁ ମୋର ମନୁଷ ପରଶୁରାମକୁ ମୋର ଘର ଆଗରେ ହାଣି ମର୍ତ୍ତେ ମାରି ଦେଲା। ସେ ମୋର ମନୁଷ ପରଶୁରାମକୁ ଟାଙ୍ଗିଆରେ ହାଣିବା ସମୟରେ ମୋର ଝିଅ ବୁଧବାରୀ ଓ ଆମ ସାହି ଲକ୍ଷ୍ମା କଚିମ ଓ ଯମୁନା ସୁନା
ତାର ଯୋଉ ସାନ ଝିଅ ତା ନାଁ କଣ?
ବୁଧବାରୀ ଲକ୍ଷ୍ମା 2 ଜଣ।
PW କିଏ? 5 and 6। ଆଚ୍ଛା, PW5 ହେଲା ବୁଧବାରୀ। PW5 ଆଉ ଗୋଟେ ହଉଛି ଲକ୍ଷ୍ମା କଚିମ ଏକ୍ସାମିନ ହେଇଛି PW6। ଆଚ୍ଛା, ତାପରେ ଓ ଯମୁନା ସୁନା ଏକ୍ସାମିନ ହେଇନି ବୋଧେ? ନାଇଁ ହେଇନି। ଆଚ୍ଛା, ଘଟଣାସ୍ଥଳରେ ହଁ ପଢନ୍ତୁ।
ଘଟଣାସ୍ଥଳରେ ଉପସ୍ଥିତ ଥିଲେ ମଧ୍ୟ କେହି ଡର ଲାଗିବାରୁ ଆମେ ମୋର ଅଣ୍ଡରାକୁ ବଞ୍ଚେଇ ପାରିଲି ନାହିଁ। ଗୋବିନ୍ଦ ମୋର ଅଣ୍ଡରାକୁ ମର୍ଡର କରି ଟାଙ୍ଗିଆକୁ ସେଇଠାରେ ଛାଡ଼ି ଦେଇ ବାଡ଼ ଡେଇଁ ପଳାଇ ଗଲା। ସେ ବାଡ଼ ଡେଇଁ ଯିବା ସମୟରେ ତାର ଦେହ ଆଞ୍ଚୁଡ଼ି ହୋଇ ଖଣ୍ଡିଆ ଖାବରା ହୋଇଯାଇଅଛି। ଲେଖି ପଢି ଜଣାଇ ଦେବାରୁ ମୋର କହିବା ମୁତାବକ ଠିକ ଭାବରେ ଲେଖା ହୋଇଥିବା ଜାଣି ମୋର ଠିକ ଅଛି ମୁଁ ଦେଲି।
ଏଇଟା ଜ୍ୱାଇଁ ଶ୍ୱଶୁରକୁ ମାରିଛି ଏଇଟା ତ?
ଜ୍ୱାଇଁ ଶ୍ୱଶୁର ମାରିଛି।
ଆଚ୍ଛା, ଏ ତାର ଆଇ ୱିଟନେସ ଥିବେ? ଝିଅ ମାନେ ଅଛନ୍ତି 4, 5, 6 ସିଧା ପଳେଇ ଆସନ୍ତୁ ସେଠି। 4, 5, 6 ଏଭିଡେନ୍ସ କୁ କର।
ସୁନା ମଣି ଖମାରୀ
ପଢନ୍ତୁ।
ସୁନା ଇନଫର୍ମାଣ୍ଟ
ମାନେ ଏଇଟା ହଉଛି ଇନଫର୍ମାଣ୍ଟ। ଅଛି।
This is the Potram as my husband. I know the accused who is my son-in-law. He has married my daughter Budhuvari.
ବୁଧବାରୀ ହେଲା PW5।
PW5. Zero. My husband died about 9 months back. At the 11th time, my daughter and son-in-law were staying separately in a house which is very near to our house. The occurrence took place on one day at about 2 p.m. At that time, my daughter was coming to our house with fish curry to serve the same to my husband. Seeing that the accused came to our house with an axe tangia and killed my husband by means of the said tangia. The accused gave successive blows to the head and neck of my husband. Due to such blow, my husband died. My daughter Budhwari and one Lakshma Kochim and witnessed the occurrence.
After killing my husband, the accused fled away from the spot by running. While running, the accused fell down and sustained injury on his leg. The above incident took place just in front of my house. One Krishna Madhukami
Matkami.
This
Madhukami.
PW7. No,
So subscribe the
Describe the
private the FIR as per my instruction. After the FIR was scribed, the contents of the FIR was read over and explained to me. After knowing the contents of the FIR, to correct, I put my LTI. MO is on the FedEx. My son-in-law used to assault my daughter.
son-in-law used to assault my daughter. Yes.
My son-in-law used to assault my daughter. They were quarreling each other. Cross-examination by defendants. The accused at the relevant time brought the axe from our house and dealt blows to my husband. At the relevant time, my husband was abusing the accused. The axe belonged to us. It is not a fact that my husband tried to assault the accused. It is not a fact that there was a quarrel between my husband and the accused, and that due to fall on the axe, my husband died. It is not a fact that my husband assaulted the accused as a result he sustained injury on his legs. The accused used to quarrel with us. I had not reported at the PS about any gondogolo with the accused. And thereafter,
So, what is your comment on this witness? What has been stated in the chief, that is also the story or the narration in the first information report? Whatever, there is no contradiction as such.
due to provocation, Miller. And
What provocation?
married
ଝିଅ ଆଣିକିନି ବାପା ଖାଉଥିଲା ମାଛ ଦେଲା, ଇଏ
ଗାଳି ଦେଲା, ଇଏ ଗାଳି ଦେଲୁ ତା ବାପା ବି ତାକୁ ଗାଳି ଦେଇଛି। ଏଫଆଇଆର କହିଲେ ବାପା ମଧ୍ୟ ତାକୁ ଗାଳି ଦେଇଛି, ବିରକ୍ତ ଦେଇଛି ଏବଂ ସବୁବେଳେ ଏବଂ ସେଥିରେ ସେ ମଦ ପିଇଥିଲା ମଧ୍ୟ।
କିଏ ମଦ ପିଇଥିଲା?
ଆପିଲାଣ୍ଟ। ତେଣୁ ସେ ମଦ ପିଇକି ସେ ଆସିଥିଲା, ତେଣୁ ବାପ ଯେତେବେଳେ ମାଛ ଦେଲା, ତେଣୁ ଇଏ ତାକୁ ରାଗିଛି ଯେ ମୁଁ ସେପାରେଟ ଥିଲି, ମତେ କାହିଁକି ଦେଇଛୁ?
What is the provocation? Who was the aggressor that way? When the daughter served peace. How?
ଆରେ ଝିଅ ଆଣିକିନି ବାପାକୁ ମାଛ ଦେଲା ତରକାରୀ, ବାପା ଖାଉଥିଲା ଦିନ 2ଟା ବେଳେ, ଆକ୍ୟୁଜ୍ଡ ଆସିଲା ମାଛ କାହିଁ ଦେଲା ବୋଲି
he challenged his wife.
ଆଉ ଆକ୍ସ ଆଣିକିନି ମାରଲା, ରିପିଟେଡ ବ୍ଲୋଜ ଦେଇଛି। ଆଉ ଡିସିଜ୍ଡ କଣ ପ୍ରୋଭୋକେସନ?
ଦେଖି ମୋର ମନୁଷ ମୋର ଜୋଇ ଗୋବିନ୍ଦକୁ ଗାଳି ଦେଲା।
What is that? It's a spontaneous reaction on the part of the, has to be, it's quite natural. What is the question of provocation? It's a natural response.
ମୋର ଝିଅ ବୁଧବାର ମାରପିଟ କରୁଥିଲା, ମୋର ମନୁଷ ସବୁବେଳେ ପ୍ରଶଂସିତ କାରଣ କରୁଥିବ, ମୋର ଜୋଇ ଗୋବିନ୍ଦ ତା ସହିତ କଳି ଝଗଡା କରୁଥିବ।
ଝିଅଟାକୁ ଯେତେବେଳେ ଆପଣ ମାରିବେ ତା ଝିଅକୁ, ବାପା ହିସାବରେ ସିଏ ପ୍ରୋଟେଷ୍ଟ କରିବନି? ବାପା ମା ହିସାବରେ ସେମାନେ ପ୍ରୋଟେଷ୍ଟ କରିବେନି? ଆପଣ ସେଇ ପାଖରେ ଆସି ରହୁଥିଲେ ଏବଂ ସିଏ ଯେତେବେଳେ ତା ସାମ୍ନାରେ ଝିଅଟାକୁ ମଦ ପିଇକିନି ବାଡିଆ ବାଡି କରୁଛି, ସେ ପ୍ରୋଟେଷ୍ଟ କଲା, ତା ଦେହରେ କଣ ଇଏ ହେଲା? ତାପରେ ସେ ଖାଉଥିଲା, ଝିଅ ଆଣିକିନି ମାଛ ତରକାରୀଟା ଦେଲା, ତାପରେ ଇଏ ପାର୍ଟି କଲା ଏବଂ ତାପରେ ଟାଙ୍ଗିଆ ଆଣିକିନି ସକ୍ସେସିଭ ବ୍ଲୋଜ ଦେଲା। ଆପଣ ଯୋଉ ସବମିଶନ ଟା କରୁଛନ୍ତି ଆଗ୍ରେସର ବୋଲି, କୋଉଠୁ ଆଦିର ଆଗ୍ରେସର କିଏ?
No.
There is nothing.
Your suggestions are also being denied. It is not a fact that my husband tried to assault the accused.
No,
whatever. Even quarreling. No. Kali jhagada, seta.
Suggestion ta ଦେଇଛନ୍ତି, ସେ deny କରୁଛି।
Context କଣ ଥିଲା?
Time my husband was abusing the accused.
What was the context? Can it be said that it's a provocation, or it is in the context that because the daughter of the deceased was being consistently inflicted torture, father used to protest?
ତାଙ୍କ ଘରୁ ଆଣିଲା ସେ
ତାଙ୍କରି ଘରୁ, yes, because he was
ତାଙ୍କ ଘରୁ ଆଣିଲା.
ହଁ
The accused at the 11th time brought the axe from our house and dealt bolt to the husband.
କୌଣସି ଗୋଟେ ମନେ କରନ୍ତୁ ହଠାତ୍ ଗୋଟେ ସଡନ କ୍ୱାରଲ ହେଇଥାନ୍ତା, ସେଇଠୁ ଗୋଟେ ଜିନିଷ ପିକଅପ୍ କରିଥାନ୍ତା,
ସେଇଟା ତ
ପିଟି ଦେଇଥାନ୍ତା, ଗୋଟେ ଅଲଗା କଥା। ତା ଘର ଭିତରୁ ଯିବେ, ସେଠୁ ଟାଙ୍ଗିଆ ନେଇକି ଆସିବେ, ତାକୁ ରିପିଟେଡ ବ୍ଲୋଜ ଦେବେ। ସେ ପୋଷ୍ଟମର୍ଟମ ଡକ୍ଟର କିଏ?
P11
P9.
P9.
11 is the injured.
P9, yes.
How many blows you have given?
3 incised. See,
First incised wound on the left shoulder, second incised wound on the center of the neck, third incised wound on the right side of the neck, fourth lacerated wound on the parietal part of the head. Acha, fracture of thyroid cartilage, larynx. Above injuries are antemortem in nature. Death is homicidal. The injuries are sufficient to cause death in ordinary course of nature. Cause of death was due to hemorrhage due to the injury over the neck. And he examined the weapon of offense, that is axe, which was produced by the police, and submitted his report and stated that the injuries found on the body of the deceased will be caused by the weapon of offense. So, who is the that injured man? How would it get?
ସେ ଯୋଉ accused ଦେଇ ପଳେଇଲା ବେଳେ ଯୋଉ
appellate himself, while he was fleeing away,
ସେ ପଳେଇଲା
came
ବେଳେ
across
ଗୋଡ଼ ଖଣ୍ଡିଆ ହେଇଥିଲା ତାର।
barbed arrows.
That is the PW11.
ତାର examine ହେଇଛି ତ? So that means the evidence is
Govinda Pujari.
ଗୋବିନ୍ଦ ପୂଜାରୀ।
bruised and average.
ଗୋବିନ୍ଦ ପୂଜାରୀ
All these injuries are simple in nature, might have been caused by falling down while running. All these injuries may be possible by wooden portion of the axe, by repeated strokes on the different portion.
Babu, right foot, scapula and right.
Aja, when suppose that is your plea which has been suggested, but you should have also taken that plea in the accused statement. Accused statement रे କହିଥାନ୍ତେ ନା ମୋ ଶଶୁର ମତେ ଗାଳି କଲା, ମୋ ସାଙ୍ଗରେ ଝଗଡା କଲା, ମତେ ପିଟିଲା, ତାପରେ ଏମିତି ଘଟଣାଟା ହେଲା। ଆପଣ କିଛି କହିଲେନି accused statement ରେ, ଖାଲି କହିଲେ ମୋ ବିରୁଦ୍ଧରେ ମିଛ କେସ୍ ହେଇଛି, ଆଉ ସବୁ ମନା କରିଦେଇ ଚାଲିଗଲେ। This plea which you have taken while confronting the eyewitnesses, that is given a complete go by in your accused statement. So how can you establish such thing? बाकी 5 नंबर साखी को आसନ୍ତୁ आई विटनेस ଦେଖିବା ଅଛି କଣ କହୁଛି ଯୋଉ ତା ଝିଅଟା
ବୁଧବାରୀ
ପଢନ୍ତୁ।
accused Govinda Pujari is my husband. P4 Sunavane Khora is my mother. This is the Rostam was my father. My father with the accused was
my marriage with the accused.
My marriage with the accused was solemnized about 3 years back. We were staying separately adjacent to the house of the parents. After marriage, the accused, under the influence of a liquor, used to insult me. He was quarreling with me. My father died 8 to 9 months back. On the date of occurrence, at about 2 p.m., I was going to my parents' house with his fish curry for my father. The accused arrived there. My father asked him as to why he was quarreling with me. At this, the accused brought one axe from the father's house and dealt blows to my father on his neck and head. Due to assault, my father died instantly.
Instantaneously.
Instantaneously.
Yes, that means the successive blow inflicted on the vital part of the body did not even allow the injured or the deceased to survive for a while. It is an instantaneous death. Tapre?
MOI is the said axe.
He has identified that weapon. Then
after murdering my father, the accused left the spot by running. While he was running, the accused fell down and sustained injury on his leg. One Latsma Kohim
That is PW6.
PW6, the occurrence at the relevant time. My father did not tell anything to the accused prior to the above incident. He was assaulted by the accused and died instantaneously. Cross-examined by the defense. I alone came to the house of my father with fish curry for my father. My husband arrived near my father's house being unarmed. It is not a fact that my father judged the accused to assault him by means of the said acts. It is not a fact that I have stated before the police that my father at the relevant time abused the accused. The house where house where we were staying was provided by my father. It is not a fact that there was no dispute between us. Witness Lakshma Kohim is the adjacent neighbor. It is not a fact that I am deposing falsely at the instance of my mother. And the deposition of the opposite under 6, that PW6, PW6. I know the accused in this case, PW5 Budhwari is the wife of the accused. I know the deceased Posram. He died about 10 months back. On the date of occurrence, I found that accused dealt axe blows to the neck and head of the deceased. Due to assault, the throat of the deceased was cut. Due to assault, the deceased sustained bleeding injury on his neck and head, and he died instantaneously. Out of fear, I left the spot being a lady. I am the adjacent neighbor of the deceased. Prosecution by defense. On the date of occurrence, I had been to market. I have not
been examined.
I have not been examined by the police in the case at the relevant time. I was returning from the market and found the accused assaulting the deceased by giving successive axe blows. Except the assault, I cannot say if there was any mark between the deceased and accused. It is not a fact that I have. It is not a fact that I have stated before police that later on I came to know that there was a gondola between the deceased and the accused. It is not a fact that I have not been.
I have not seen.
I have not seen anything to this case, and that I am deposing falsely.
The entire the three witnesses, as you have read already, with the cross-examination, as we find that they are consistent with each other. That this PW5 came to serve some fish curry to his father, who is the deceased in this case. And at that point of time, the appellant came and he raised some objection. Then he entered inside the house of the deceased, brought axe and dealt blows on the vital part of the body like head and neck. Now say neck ro jo impact ta jo blow ro impact ta jaha thila, which appears from the postmortem report that
all fatal blows.
It was the fracture of thyroid cartilage of the larynx. How injuries are sufficient in ordinary course of nature to cause death. ହେଲା ଆଉ ଡକ୍ଟର ମଧ୍ୟ ଏକଥା କହୁଛନ୍ତି ଯେ ଯୋଉ ୱେପନଟା ସିଏ ସେଠି ପଡିଥିଲା ଯୋଉଟାକୁ ୱିଟନେସ୍ ମାନେ ବି ଆଇଡେଣ୍ଟିଫାଇ କରିଛନ୍ତି particularly PW5 ବୋଧେ ଆଇଡେଣ୍ଟିଫାଇ କରିଛି MO1 that was also produced before the doctor who conducted postmortem examination, and he verified it and opined that these injuries are possible by the weapon. So, and so far as your injuries are concerned, it is not that they are not explaining the same. They are stated that after assaulting, while you are running away and trying to jump that boundary fence, you fell down on it and sustained some injuries. And the doctor has noticed some bruises and abrasions and opined that those are simple in nature. the plea which you have taken that the appellant chased, the deceased chased you, holding that axe and also assaulted you. That was just the plea which has been suggested to the 3 eyewitnesses. But such a plea was not even taken in the accused statement. So the manner in which you brought the axe, the repeated blows which you have given on the vital part of the body of the deceased, the instantaneous death, and the prosecution has explained your injuries, and your plea is inconsistent. Whatever you are suggesting, that is not taken. So what is the illegality in the impugned judgment to be interfered with?
At that time, it might be the after taking the alcohol, he has done all these things.
Who has stated that alcohol he has taken? These 3 witnesses are there. 4, 5 और 6.
Taking alcohol at this spot, he was not there. He came below. He came from
ଆପଣ
outside.
ବର୍ତ୍ତମାନ ଆମ ପାଖରେ କହୁଛନ୍ତି ଯେ the appellant was under the influence of alcohol. ଆରେ 3ଟା ତ ସାକ୍ଷୀ ଥିଲେ ନା?
ନା ସାକ୍ଷୀ ଥିଲେ ସେମାନେ ଆଉ ଜାଣିନାହାନ୍ତି।
ଆଉ ଜାଣିନାହାନ୍ତି, ଆପଣ କେମିତି ଜାଣିଲେ ଏଠି ହାଇକୋର୍ଟରେ?
ଲେଖା ଅଛି ମଦ ଖାଇ ମୋ ଝିଅକୁ ବୁଝୁ ସବୁ
ମଦ ଖାଇ ମୋ ଝିଅକୁ ପିଟାପିଟି କରେ, that is ଆଗରୁ।
ମାନେ
ଘଟଣା ବେଳେ ମଦ ପିଇକିନା ଆସିଥିଲା। And if you take yourself liquor, can that be an excuse that ମୁଁ ନିଜେ liquor ନେବି and ମୁଁ intoxicated ହେବି ଏବଂ ତାପରେ ଆଣିକିନି ଜଣକୁ ମାରିବି?
Self defense.
Is it a
liquor ନେଲା ପରେ ହୁଏତ ତାର କମ
can it be taken as to have see that
What are the exceptions?
somebody, suppose without your knowledge, somebody has administered some liquor to you, and thereby that would take a different turn. But when if it
You
is your
yourself
case,
have-
yourself took the liquor, then and caused this assault, there is no question of you see 85 IPC कହୁची act of a person incapable of judgment by reason of intoxication caused against his will. So nothing is an offense which is done by a person who at the time of doing it by reason of intoxication incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to the law, provided that the thing which was intoxicated him was administered to him without his knowledge and against his consent. कौन विषय में से जनक ଦେଇଦେଲେ ସେ ଜାଣିନି ତାହାପରେ ସେ ଗୋଟେ କିଛି offense କରିବ ସେଟା ଏଇ type that's a different that is an exception. ସେମିତି unsoundness mind ଅଛି these are the exceptions there. ଏଠି ଆପଣ ଯଦି କହୁଛନ୍ତି liquor ଅବଶ୍ୟ evidence କିଛି ନାହିଁ, ନିଜେ liquor ପିଇକିନା ଆସିବେ ନେଇକିନା ଆସିବେ, ନିଜେ ଆସି ଝଗଡା କରିବେ, ତାପରେ ଯାଇକିନି ତା ଘର ଭିତରୁ ଟାଙ୍ଗିଆ ନେଇକିନା ଆସିବେ, ତାକୁ ରିପିଟେଡ ବ୍ଲୋଜ ଦେବେ ତାର ହେଡ ରେ ଆଉ ନେକ୍ ରେ, ଆଉ ତାପରେ ପଳେଇବେ ୱେପନ ଛାଡିକିନି। ତ ଏଠି ପ୍ରଶ୍ନ କୋଉଠୁ ଆସୁଛି ଯେ the deceased has caused any provocation, that was your main ground ଯେ ମତେ ବାଡେଇଲା, ମତେ provocation କଲା, ଯୋଉଥିପାଇଁ ହୁଏତ
ମୁଁ retaliate କଲି।
କରିଛି।
But this is not a case of retaliation. No.
The next year I will be.
Where is the scope of escape anywhere? See, the affair story goes in consonance with the evidence of each of the witnesses, getting assurance of the medical evidence, consistent with the kind of blows given to the vital part of the body. So where is the escape?
ବାହାରୁ ଆସିକି ଏଠି ଗଣ୍ଡଗୋଳ କରିଛି।
Where is your plea?
ମାଛ ଖାଇବାକୁ ଦେଇକି
କୋଉଠି ଆପଣ plea କାହିଁ? Story will not do.
suppose ଗୋଟେ plea ନେଇଥାନ୍ତେ ଧର ମୁଁ ମାଛ ଆଜ୍ଞା ଆଣିଥିଲି ମାଛ ତାକୁ ଇ କରିଥିଲି ସେ ମତେ ମାଛ ଇ କରି ତା ବାପାକୁ ନେଇଦେଲା ମୁଁ ତାପରେ ପ୍ରୋଟେଷ୍ଟ କଲି ବାପା ମତେ ରିଟାଲିଏଟ କଲେ ମତେ ବାଡିଆକୁ ଗୋଡେଇଲେ ମୁଁ ପଡିଗଲି ଏମିତି ସେଇ ପଦରେ ମୁଁ ଏଇ ଟାଇପର ଗୋଟେ କିଛି ମେକଆଉଟ କରିଥାନ୍ତି କେସ୍ ଏଇଟା ହିଁ ଆପଣଙ୍କର ପ୍ଲି ହିଁ ନୁହେଁ ସିଏ ଓବିୟସଲି ଯେତେବେଳେ ମାଛଟା ଧର ସିଏ ଆଣିଥିବ ସିଏ ତ ବାପା ପାଇଁ କେବେ ଆଣି ନଥିବ ନା ତାଙ୍କ ଭିତରେ ଝଗଡା ହେଇଛି ତ ସେଇ ଯୋଉ ମାଛଟା ଆଣିଥିବ ସିଏ ତା ଦେହରୁ କିଛି ପୋର୍ସନ ହୁଏତ ନିଜ ଇଏରୁ ବଞ୍ଚେଇକିନି ହଉ କି ଯାହା ବି ହଉ ନେଇକିନି ସ୍ନେହରେ ତା ବାପାକୁ ଖାଇବା ବସିଲା ବେଳେ ଦେଇଛି ସେତିକିବେଳେ ଇଏ ଆସିଛି ପ୍ରୋଟେଷ୍ଟ କରିଛି ପ୍ରୋଟେଷ୍ଟ କରିକିନି ତାପରେ it is not that extent that you will go and bring somebody from the
ମାଛ ପାଇଁ ଯାଇକି ଟାଙ୍ଗି ଆଣିବ ଆଣିକି ଆଣିବ
ହେଇଛି
that is the evidence. What do you say?
ମାଛ ଯୋଉ ମାଛ ଦେଲା ମାଛ ଦେଲା ଶଶ ପାଟିତୁଣ୍ଡ କଲା
ମାଛ ନ ହଉ ସୁଙ୍ଗିଡି ବି ହଉ କଣ ହେଲା ଅସୁବିଧା କଣ ହେଲା it is not the question, see what is the circumstance.
ତେଣୁ ସିଏ ଯାଇ ସେଠି କଣ କଲା ଗଣ୍ଡଗୋଳ କରିବାରୁ ଶଶ ପାଟିତୁଣ୍ଡ ହବାରୁ ଯାଇକି ସେ ଟାଙ୍ଗାରେ ତାଙ୍କୁ ଘରୁ ନେଇକି ଆସିଲା ସେ କିଛି ଆଣିନଥିଲା ହାତରେ ତାର କିଛି ନଥିଲା ହଠାତ୍ କି ବେଳେବେଳେ ଆଉଟ ଅଫ୍ କୋର୍ଟ ମୁଁ ଖାଲି କୋର୍ଟ ଯୋଉମାନେ ଟିକେ ଆଲକୋହଲ ଖାଇଥାନ୍ତି ବା ଡ୍ରଗ୍ସ ଖାଇଥାନ୍ତି ତାଙ୍କୁ କୌଣସି କଥା ମୁଣ୍ଡରେ ପଶିଗଲା ଯେ ସେଇଟା ଛାଡିବେନି ସେଇ କଥାଟାକୁ ରିପିଟେଡ କହି ଚାଲିବେ ହୁଏତ ମାନେ ମୁଁ ଟିକେ ଆଉ ଟିକେ ପ୍ରିପେୟାର ହେଇକି ଶ୍ରୀଜନକୁ ଜଣେଇବି ନେକ୍ସଟ ୱିକ୍ କିନ୍ତୁ ଏଇ ଯୋଉ ଘଟଣାଟା ଘଟିଛି ଏଇଟା ସେଇଭଳିଆ ଘଟଣା ହେଇଛି ଯାହାଫଳରେ କି ସିଏ ମାଛ ଦେଇଛି ସିଏ ମାଛ କିଣିକି ଆଣିଛି ଇଏ ମାଛ କିଣିକି ଯାହା ମାଛ ଧରିକି କିଣୁଛି ଯେତେବେଳେ ବାପାକୁ ତ ଦେଇଛି ମାଛ ସେଇ ସମୟରେ ଇଏ କଣ କରୁଛି ନା ଯେହେତୁ ମୋ ବାପା ଶ୍ୱଶୁର ସହିତ ମୋ ପାର୍ଟନର ହେଇଛି ଗଣ୍ଡଗୋଳ ହେଇଛି ତାଙ୍କ ସହିତ ରହୁନି ମୁଁ ବାହାରେ ରହୁଛି ତୁ କାହିଁ ମାଛ ଦେଇଛୁ ବୋଲି କରିଛି ଶ୍ୱଶୁର ତାକୁ ଗାଳି ଦେଇଛି ସେ ନିଶ୍ଚୟ ସେଠି ଗାଳି ଦେଇଛି ମୋତେ କାହିଁକି ଝିଅ କେମିତି କହିଲୁ ସେମିତି କହିଲୁ ବୋଲି କହିଛି ଯୋଉଥିପାଇଁ ଇଏ ଗଣ୍ଡଗୋଳଟା ହେଇଛି ସେଥିପାଇଁ ଇଏ ହଠାତ୍ କି କଣ ନିଜର ହିତାହିତ ଜ୍ଞାନ ଭୁଲି ତାଙ୍କ ଘର ଭିତରୁ ଟାଙ୍ଗି ଆଣି ଚାଲି ଆସିଛି
So you mean to say that there was no premeditation?
ମାଇଲେ
It has happened
ମାଇଲେ
at this spur of the moment.
ମାଇଲେ
There was no premeditation. That is how he was unarmed. Had there been a premeditation, probably he would have come with the arm.
ମାଇଲେ ସେ ଯାଇଥିଲେ ସେ ଜାଣିକି ହାତ ଧରିଥାନ୍ତା କୌଣସି ତାର ମାନେ ଇଚ୍ଛା ନଥିଲା କିନ୍ତୁ ରାଗରେ ପାଟିତୁଣ୍ଡ ହଉ ହଉ ହାତରେ ବାଡେଇବ କଣ ଯାଇକି ସାଙ୍ଗେ ସାଙ୍ଗେ ପଳେଇଛି ଗୋଟେ ପନିକି ଧରିବା ବଦଳରେ ଟାଙ୍ଗା ଧରି ଯାଇଛି ବାଡେଇଛି ଆଉ ଗୋଟେ ଥର ବାଡେଇ ସାରିଲା ପରେ ସେ ଜାଣିଥିବେ ଯେ ସେ ନିଶାଦି ଖାଇଥିବ ସେ ଗୋଟେ ଥର ଚାଲିଥିବ ନା ସେ ଚାଲୁଥିବ ତାର ମାନେ ତାର ନିଜକୁ ବାଡେଇକି କଣ କରୁଥିବ କହିପାରିବି ତାପରେ ତ ମରିଛନ୍ତି ଜାଣିଛି ତା ସେନ୍ସ ହଉ କି ଯାହା ବି ହଉ ସେ
No, we have to talk within the evidence only. Jaha bhi ho, the only aspect that you probably try to bring out in the case is it is not a premeditation. So you have to substantiate that.
Minor judgment is also there. I will give that next.
By the way, how many years you are in custody? You are directed to be released on bail by this court on 28/9/2012.
More than 8 years.
8 years.
ଆପଣ arrest କେବେ ହେଲା କି?
Arrested. Instead arrest is I have been arrested.
Final form ରେ କହୁଛି ଆପଣ 29/12/2006 ରେ arrest ମାନେ forward ହେଲେ. ବେଲ୍ ହେଲା ଆପଣଙ୍କୁ 28/9/2012.
Pura just 3 years.
Who are there in your family and what is your avocation? Have you got any idea? Who are your family members, etc.?
लोग बेल कर पर ताश को मोर की सपोर्ट नहीं कथा नहीं पता नहीं किस जानी ଦେଇଥିଲେ ବ୍ରିଫ ଟା ଲିଗାଲ ତରଫରୁ ଦେଇଥିଲେ ବସ ଦ୍ୟାଟ୍ସ ୱାନ୍ ତାର ବେଲ କରିଦେଲି ପଠେଇଦେଲି ଜେଲକୁ ପଠେଇଦେଲି ରିଲିଜ ଅନ୍ ବେଲ ସେ ଲୋକ ମୋର ଆସିଲେ କି ଦେଖା ନାହିଁ ସେ କିଏ ଲୋକକୁ ବୁଝେ ଚିହ୍ନି ନାହିଁ.
Have you obtained any report on that aspect? since he is seeking for an adjournment, we'll take up this matter next week because he is not having also the paperwork in which he might have mentioned some judgment and etc., which he has stated that taken note of it. So
Pre,
you just
pre and post conduct.
Collector.
One thing is stating that appears to be correct, and your witnesses have also stated that he has not come prepared to the spot to assault him. So something has happened at that spot for which assault took place. So what is that something, and how far the conduct of his wife in bringing that fish curry to the father without his consent, without the appellant's consent, has caused provocation. Kaରଣ ସେଇ ଟାଇମ୍ ବି ଏମିତି ଥିବ, he might be also hungry. ଭୋକିଲା ଥିବ ଏବଂ ଭୋକିଲା ଥିବ ୱାଇଫ୍ ଆଣିକିନି ମାଛ ତରକାରୀ ଯୋଉଟା ସେ ମାଛ ନିଜେ ଆଣିଥିବ ଇଏ କରିଥିବ ତା ବାପାକୁ ଆଣି ଦଉଛି, ବାପା ସାଙ୍ଗରେ ଆଗରୁ ସମ୍ପର୍କ ଭଲ ନାହିଁ, ଯାହା ଜଣା ବାପା ପ୍ରୋଟେଷ୍ଟ କରୁଛି ଯାହା ବି ହଉ, କାରଣ ଝିଅ ଜ୍ୱାଇଁ ପାଖରେ ଅଲଗା ରହୁଛନ୍ତି, ତେଣୁ ଏଇ ପରିସ୍ଥିତିରେ ତ some kind of provocation ଆସିଯିବା ବି ମାନେ ରାଗିଯିବା ବି ସମ୍ଭବ ଅଛି, ମାନେ ଭୋକିଲା
at the spot he was triggered.
ଆଉ ଇଏ ଆସି ଇଏ ପାର୍ଟି ଯଦି କରିଛି ମାନେ ଆଣିକି ଝିଅ ଦେଇଛି, ଇଏ ପାର୍ଟି କଲା ପରେ ଇଏ ଆକୁ ଯଦି ଚ୍ୟାଲେଞ୍ଜ କରିଛି, that might have also aggravated the situation, ସେଠି possibility ଅଛି, ତେଣୁ ସେଇ ସିନାରିଓରେ ଘଟଣାଟା ହେଇଛି. So there is some kind of quarrel as it appears. ସେ ମଧ୍ୟ କିଛି evidence ଆସିଛି, but ଯେହେତୁ ତାକୁ ଡିଫେନ୍ସ କାଉନସିଲ ମାତ୍ରା ସେଟାକୁ ଆଣି ନାହାନ୍ତି, better way ରେ cross examination ଆହୁରି ହେଇପାରିଥାନ୍ତା, but it seems from the FIR also, FIR ଟା ବାହାର କଲା ଉପରେ
page 24.
FIR ରେ ମଧ୍ୟ ଲେଖିଛି ଯେ ପାଟିତୁଣ୍ଡ ହେଲା ବୋଲି ଗୋଟେ ଲାଇନ ରେ, ଆଗରୁ ତ ପାଟିତୁଣ୍ଡ ହେଇଥିଲା, ମାରପିଟ ହଉଥିଲା,
ମାଛ ତରକାରୀ ବାପାକୁ ଆଣିବା ପାଇଁ ଯୋଉ ଗୋବିନ୍ଦ ଝିଅ ବୁଧବାରକୁ ମାରପିଟ କଲା, ୟା ଦେଖି ମୋର
ଗୋବିନ୍ଦ ରିସା ହୋଇ ମୋ ଠାରୁ it is on the very day earlier to that. 2 ଘଟିକା ସମୟରେ ମୋର ସ୍ୱାମୀ ମୋର ଘର ପିଣ୍ଡାରେ ଖାଉଥିଲା ସେ ଆଣିକି
ମୋର ଝିଅ ବୁଧବାରୀ ଘରେ କରିଥିବା ମାଛ ତରକାରୀ ତାର ବାପାକୁ ଆଣିବାରୁ ମୋର ଯୋଉ ଗୋବିନ୍ଦ ଝିଅ ବୁଧବାରକୁ ମାରପିଟ କଲା, ଏହା ଦେଖି ମୋର ମନୁଷ ମୋର ଜୋଇଁ ଗୋବିନ୍ଦକୁ ଗାଲି କଲା. ହଁ, ଏଇ ଯୋଉ ଜିନିଷଟା ମାରପିଟ କଲା ମାନେ ତା ନିଜ ସ୍ତ୍ରୀକୁ ବାଡେଇଛି ବୋଧେ, ମାରପିଟ ମାନେ ସ୍ଲାପ ଏଇ ଟାଇପ ର କିଛି ଗୋଟେ ହେଇଛି, ଯୋଉଟାକୁ ଇଏ ତାକୁ ବାପା ପ୍ରୋଟେଷ୍ଟ କରିଛି, ଗାଳି ଦେଇଛି ଓବିୟସଲି, ଯୋଉଟା କି ସିଚୁଏସନ ଆହୁରି ଆଗ୍ରାଭେଟ କରିଦେଇଛି, ଏବଂ ସିଏ ଯାଇକିନି ମୋ ଘରୁ ସିଏ କହୁଛି ମୋ ଘରୁ ଏକ ଟାଙ୍ଗିଆ ଆଣି ମୋର ମନୁଷକୁ ହାଣିଦେଲା.
ଉପର ପାରାରେ ବି ଲେଖିଛନ୍ତି, ଗତ 3 ବର୍ଷ ତଳେ ମୋର ସାନ ଝିଅ ବୁଧବାରୀ ମେତୁଆଡା ଗ୍ରାମର ହରି ପୂଜାରୀଙ୍କ ପୁଅ ଗୋବିନ୍ଦ ସହ ପ୍ରେମ ବିବାହ କରିଥିଲା. ବିବାହର 6 ମାସ ପରେ ମୋର ଝିଅ ଓ ମୋ ଜ୍ୱାଇଁ ମୋ ଘରେ ଆସି ଅଲଗା ରୋଷେଇ କରି ଖାଇ ରହିଲେ. ମୋର ଜ୍ୱାଇଁ ଗୋବିନ୍ଦ ପ୍ରାୟ ସମୟ ମଦ ଖାଇ ମୋର ଝିଅକୁ ବୁଧବାରୀକୁ ମାରପିଟ କରୁଥିଲା. ମୋର ମନୁ ସ୍ୱାମୀ ପରଶୁରାମ ଏଥିରେ ବାରଣ କରୁଥିବାରୁ ମୋର ଜ୍ୱାଇଁ ଗୋବିନ୍ଦ ତା ସହ କଳି ଝଗଡା କରୁଥିଲା.
ସିଏ ତା ସ୍ତ୍ରୀକୁ ବାଡିଆ ପିଟା କରେ, ଯୋଉଟା କି ବାପା ହିସାବରେ ଇଏ ପାଟିତୁଣ୍ଡ କରୁଛି ଏବଂ ସମ୍ପର୍କ ଇଏ ହୋଇଛି, ଏବଂ ବୋଧେ ଅଲଗା ଅଲଗା ରୋଷେଇ କରି ଖାଉଥିଲେ, ସେପାରେଟ ରହିଥିଲେ, ଏବଂ ସେପାରେଟ ମେସ୍ ରେ ରହିଲା ପରେ ଏଇ ଘଟଣାଟି ସେଇଦିନ ହେଇଛି 27/12/2006. ଆଉ ଦିନ 2ଟା ଖାଇବା ସମୟଟା ଇଏ ମାଛ ଆଣିକିନି ବାପାକୁ ଦେଇଛି, ଇଏ ଆସି ପ୍ରୋଟେଷ୍ଟ କରିଛି, ବୋଧେ ପିଟାପିଟି କରିଛି କଣ ଇଏ ତାକୁ ଡିସିଷ୍ଟ
protest
ଗାଳି କରିଛି ଆଉ ତୁ କାହିଁ ମୋ ଝିଅକୁ ପାଟି କରୁଛି ଏଇ ଟାଇପ ର obviously ଯୋଉଟା କି ସିଚୁଏସନ ଟାକୁ ଆଗ୍ରାଭେଟ କରିଛି ଏବଂ ସିଏ ଯାଇକିନି ଟାଙ୍ଗିଆ ଯାଇକି so you collect that information we'll take it on Tuesday Tuesday ରଖିଦବା acha hard ଲେଖନ୍ତୁ Mr. Dilip Roy land counsel for the appellant you keep that paper book with you the land counsel for the appellant placed the evidence of the witnesses and seeks for an adjournment till next week for further hearing for further argument. The learning counsel for the it appears that the appellant was taken into judicial custody in connection with this case on 29/12/2006 and during trial he was throughout in custody and during pendency of the appeal he was granted bail by order dated 28/9/2012. Let the Land Council for the state obtain instruction regarding the avocation of the petitioner, the family, and also the conduct of the appellant pre as well as post conduct conviction post after being released on bail the report should be produced on the next day. You can also search for those decisions that you power of self-control, your resistance, that is not same in all the cases. Somebody may be very patient. Somebody may, in a particular situation, may not react to that extent. But in tribal areas, what happens that when little things they used to get provoked and they used to commit offense.
It is all trivial issues.
ଛୋଟ ଛୋଟ ଘଟଣା ପାଇଁ ମର୍ଡର କରିଦିଅନ୍ତି ମର୍ଡର କମ even if instances are there ମୁଣ୍ଡ କାଟିକି ନେଇକି ଯାଆନ୍ତି ଭାରି ଥାନା ତେଣୁ ସେଇଥିପାଇଁ କୁହାଯାଏ ଯେ ତାଙ୍କର ମାନେ ରେଜିଷ୍ଟାନ୍ସ ପାୱାର ନିଜକୁ କଣ୍ଟ୍ରୋଲ କରିବାର ଇଏଟା ନଥାଏ ଡିପେଣ୍ଡସ୍ upon the person to person ତାଙ୍କର social background many things depend ତାଙ୍କର lack of education ହଉ ଇଏ ସବୁ depend ତେଣୁ ଏଇ ଜିନିଷଟା ଆମ ଇଏରେ ହୁଏତ ଗୋଟେ ଛୋଟିଆ ଲାଗିପାରେ ମାଛ ତରକାରୀଟା ଆଣିକିନି ବାପାକୁ ଦଉଥିଲା ଆଉ ବାପା ଇଏ ଆସି ପାଟି କଲା ବାପା ଯଦି ବି ପାଟିତୁଣ୍ଡ କରୁଥିବ ସିଏ ଏଇଟା କଣ ଏମିତି ଗୋଟେ ସିଚୁଏସନ ହେଇଥିବ ବଟ୍ ଇଟ୍ ତାଙ୍କର ସିଚୁଏସନ because it belong to Malkangiri na Malkangiri tribal area so semanakar reaction ଭଲ ଥାଏ
ସୁନ୍ଦରଗଡ଼
ସୁନ୍ଦରଗଡ଼ ନା Malkangiri
No.
Malkangiri. The court of
Malkangiri
judicial.
ସୁନ୍ଦରଗଡ଼
କିଛି ସୁନ୍ଦରଗଡ଼ ଲେଖୁଛି
କୋଉଠି ମାଡକାମି ପରା ମାଡକାମି ନାଁରେ ଜାଣି
ମାଲକାନଗିରି
Malkangiri
ସେସନ ମାଲକାନଗିରି your ସାଙ୍ଗ ବାଡବାଡି ହେଲେ ବାଡବାଡି
there are many cases
there are many cases
particularly from this as you say Koraput Nabrang Malkangiri ଏଇ ସବୁ belt ରୁ
ମୋର ଆଉ ଟିକେ
ଏଇ type ର ଇଏରୁ ବହୁତ କେସ୍ ଅଛି ଏଇ type ର ଛୋଟ ଛୋଟ ଘଟଣା ନେଇକିନି ବହୁତ ସମୟରେ trivial issues But trivial quarrel is someone both reactive here. Reactive making offense committed. All right. Anybody else? Next matter dakho.
Item 11.
Aadhaar कर दो ना 2/12/2025. Next. Item 11.
When the report has come,
Yes, what is the report?
report has come, but it create confusion by adding up.
State?
Where is that I have verified from a such and such rural state, forgot. No, he is Ali, public well-being. तुम सेटा confusion है.
नहीं Ali ଅଛି ନା नहीं?
ସେ no ଟା add କଲା ପରେ correct ସେଟା confusion sir.
No, he is alive.
Next week that we have already implemented.
Well-being ର spelling ଦେଖୁନ ଲେଖିଛନ୍ତି IIC ଗୋଟେ ସେ well-being ର spelling ଲେଖିଛନ୍ତି WEEL. The report is to be furnished to the High Court and is PS कौन लिखी जी रुरला बोली ଗୋଟେ थाना है
rural ସେଟା actually
rural ବନାନ लिखी RURLA ଏଟା କିଏ କଲା ହେଇଯାଇଛି
ଯେମିତି କହିଲେ CCT ସେମିତି ଜାଣିକି ପ୍ରଥମ କର.
The Land Council has placed a report dated 27/11/2025 of the IIC Town Police Station Burger and submits that the report is confusing and therefore the matter may be taken up next week in order to obtain a correct report. And you talk to that IIC. ଆପଣଙ୍କର ଯୋଉ English language ରେ judge ମାନେ ବହୁତ ଖୁସି ହେଇଗଲେ ବହୁତ ଭଲ ଲେଖିଛନ୍ତି. The report is taken on record. Yes, next.
Item 12.
Ali was no?
Ali.
From the Land Council for the state has produced the report dated 36/2025 of the IIC Burla Police Station, Sambalpur. It shows that the appellant is alive. The report is taken on record. Paper Nandi, Land Council for the state has received the paper book. Land Council for the appellant submits that she is yet to receive the paper book. Let the paper will be supplied to the Land Council for the appellant during course of the day. The signature. Get prepared. We'll take up this matter on 9th of December. Matter will be listed on 9th December 2025 for hearing. Yes.
Item 13.
Item 13, may I please, Your Lordship?
Yeah.
Your Lordship, on the last occasion, an affidavit was filed on behalf of the contemner, stating that they would comply within 2 months, Your Lordship. An adjournment was granted to apprise the court regarding the development of the same, Your Lordship.
Our affidavit is informed further time of 2 months is required for compliance of the affidavit is taken on record. Amitabh Das also made that matter will be taken off on such and Mr. Das.
The compensation award is already been processed by us. It will be noticed. It will require only 7 to 10 days are required.
ଆମେ ଯେପର୍ଯ୍ୟନ୍ତ ତାର ନଈ ପୁଣି ତାକୁ ଡିସ୍ପୋଜ ଅଫ୍ କରିଦେଲେ
ନା ନା ନା
ତେଣୁ କେବେ ଆପଣ କହିଥିଲେ ଆଜି ରଖିବାକୁ ଆମେ ରଖିଲୁ ଆଣିଲୁ
ତାଙ୍କ ନା ନୋଟିସ ଦିଆ ହେଇନି ନୋଟିସ ଦିଆ ହେଇଥିଲେ ପେମେଣ୍ଟ ଦିଆ
ଏତେ କଥା ଆପଣ କେବେ କୁହନ୍ତୁ ଆମେ ରଖିଦବୁ
18 ରଖନ୍ତୁ 18 ରଖନ୍ତୁ
13 14 15 16 all are connected.
ହଁ ହଁ
ମତେ ଗୋଟେ ଚିଠି କରିଛନ୍ତି ଅଲରେଡି ସେ ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ଅଫିସର କହିଲେନି ତ ଟଙ୍କା ବି ଯାଉ ଗୋଟେ ଏଷ୍ଟିମେଟ କରି ଟଙ୍କା ଦବା ପାଇଁ
ପଇସା ତାକୁ ପହଞ୍ଚିବ ସେ ପୁଣି ନହେଲେ ଆସିବ
କମ୍ପ୍ଲାଏନ୍ସ ଆଫିଡେଭିଟ୍
ଆପଣ 18 ରଖନ୍ତୁ ତା ଭିତରେ ପେମେଣ୍ଟ ହେଇଯିବ
କେବେ
18 December.
It will be paid.
Mr. Amitabh Das, land senior advocate, appearing for the contemner opposite party, submits that some more time is required for compliance of the order passed by this court dated 5/9/2024 in WPC number 2228 of 2024. On consensus of the parties placed this matter on 18th of December 2025. The
Obliged, Your Lordship.
apprised this court about the development made in the meantime. Yes.
Obliged.
14-15 ମ୍ୟାଡ଼ାମ
14ଟା ବି same order ତ?
ନାଇଁ 15-16
No, Your Lordship. 15 and 16.
15 and 16. Mr. Mahanti, you are in that case. The same.
Yes, I have already received the, so that I have already instructed the land acquisition officer to prepare the estimate and implement the concerned petitioner for payment.
Same to ଏପର୍ଯ୍ୟନ୍ତ ପଇସା ତାଙ୍କ ପାଖରେ ପହଞ୍ଚିନି।
ନାଇଁ ସେ land acquisition officer କୁ ଆମେ direction ଦେଇଦେଇଛୁ ସେ because
dispose of ଆମେ କରିବୁନି ଆପଣ
ନାଇଁ ମୁଁ I will file a complaint and due to lawsuit.
ଲେଖନ୍ତୁ ସେ ରିପୋର୍ଟ ନେଇ ଆସନ୍ତୁ ଶୁଣାନ୍ତୁ and submit that the matter may be taken up ଯେମିତି ଆଦେଶ ଲେଖିଲେ ସେମିତି ଲେଖିଦେବେ ସେଇ 18/12/2025 yes ତାପରେ 14 ନମ୍ବର ଟା କଣ ହେଲା କୁହନ୍ତୁ
Item 14.
They have taken several adjustment measures for disbursing the compensation amount.
Item 14 Miller.
Disbursed.
No, not at only 17 dismissal of land Miller, rural land. Valuation is approximately 1 lakh.
No, that part is all.
They have taken
Now,
The district compensation advisory committee was a joint meeting was held on that day. My lord, the petitioner was present on that meeting, and the money has been sanctioned and sent to the government for the
approval.
disbursement.
ସେଟା ତ ଲେଖିଛନ୍ତି ଆପଣ
ନାଇଁ ଏଇଟା
ସେଇଆ କହିଥିଲେ
ନାଇଁ ଏଇଟା କମିଟି 6-11 ଏଇ 6-11 ସେମାନେ ମିଟିଂ ରେ ବସୁଛନ୍ତି
ମାସେ ଟାଇମ ନେଇଥିଲେ ଲାଷ୍ଟ
just a minute କଣ ଲେଖିଛନ୍ତି କୋଉଠି ପଢନ୍ତୁ the meeting of the district so and so under this so and so ଆଚ୍ଛା ଏଇଟା 6/11/2000 ଏ ଅର୍ଡର ଟା କେବେ ପାସ୍ ହେଇଥିଲା କି ତାପରେ 23/10 ଆଚ୍ଛା ତାପରେ ଗୋଟେ ମିଟିଂ ହେଲା
ତାପରେ
ମିଟିଂ ରେ କଣ ହେଲା ଆପଣଙ୍କର
deliberations.
yes my lord ପ୍ରେଜେଣ୍ଟ ରହିଛନ୍ତି ଏବଂ ଆମାଉଣ୍ଟ ମଧ୍ୟ
ଇଏ ଥିଲା ଆପ୍ଲାଣ୍ଟ ଏ ପିଟିସନର ଥିଲା
ଥାର୍ଡ ପେଜ ଥାର୍ଡ ରେ ଅଛି ସୌମେନ୍ଦ୍ର ମହାନ୍ତି ଲ୍ୟାଣ୍ଡ ଲୁଜର ହିସାବରେ 3 ଜଣ ଲ୍ୟାଣ୍ଡ ଲୁଜର
ଆଚ୍ଛା ଠିକ ଅଛି ସେଠି କଣ ଡିସିସନ ଆପଣ କଲେ ରେକମେଣ୍ଡେସନ କଲେ
ଲେଖନ୍ତୁ ନେଇଛି ଏବଂ ତାଙ୍କର ଯୋଉ ଖାତା ନମ୍ବର 74 ପ୍ଲଟ ନମ୍ବର 79 that 9 decimal ଆମ ହେଇଛି ତାପରେ ତାଙ୍କର
ଭ୍ୟାଲୁଏସନ ରିପୋର୍ଟ ମଧ୍ୟ ଆପଣ
valuation report ମଧ୍ୟ ହେଇଛି
ଆଚ୍ଛା ବଟ କେବେ ରଖିବା କୁହନ୍ତୁ
18th December
18 ଲେଖନ୍ତୁ the Land and Council for the state has produced the proceeding in the district compensation advisory of the district compensation advisory committee bracketly DCAC meeting which was held on 6/11/2025 and it appears that the petitioner was present the petitioner was present in that meeting and decision has been taken after the superintending engineer Jarka Irrigation Division submitted the valuation report after which was approved by the DCAC and the committee after due verification and discuss approved the compensation. The Land Council for the state seeks some more time to obtain further instruction in the matter. List this matter on 18th of December 2025. This is taken on record for you. ଆଉ କିଏ ଅଛନ୍ତି ନାଇଁ ଏଇଟା ଗୋଟେ ପାଠ ହେଇଥିଲା
କିଏ ଥିଲେ ଶିବ
And 14 taking into account appropriate decision, especially the dying declaration of the deceased, and the recovery of weapon of offense.
Item 17.
Seven.
Yes.
Seven. PW 7 minor.
Let her come.
We are just coming within 2 minutes. Ask her to come, huh?
Minor.
हियरिंग रो टॉप ऑफ लिस्ट रे अछि आ कोन आपण भाबुचंदी ऑर्डर्स पूर्वरु आनिबे ना कोन
नेक्स्ट वीक के काम କରିବାକୁ ଚାହୁଁଛି
ऑर्डर कोन लिखा ହେଇଥିଲା ଗତ ଥର यो लास्ट टाइम 25 गला तो अंशु अच्छा इधर लिखा है आडिन पार्ट लिखा है नी पत्थर पान कोन कहथिलो सुनानी ହେଇଥିଲା ବୋଲି को काई को ऑर्डर लिखा है नो अच्छा हाँ ता पूर्व हाँ तो आपण 6/11 आपण जान जान सुनानी आरंभ ही गलानी तापर पुनी
ତାପରେ ପଡି ନଥିଲା ରିଚ୍ କରି ନଥିଲା
25/11 ରେ ଆମେ ତ से जो बाबू माने देले तांकर रिपोर्ट देले जो भूल भाल ही जाइतला पेपर बुक रे से दिन कोन सुनानी नहीं नथला किछ
दी थर आर लास्ट वीक रे हेनी सुनानी लास्ट वीक रे
we are taking of them next week तो 2 तारीख आपण रेडी ही जाम आउट टाइम नेबे नहीं हां देखो श्रीमती मंदाकिनी पंडा लैंड काउंसिल फॉर द appellant is present and 6 for an adjournment till next week. Is this matter on 2nd of December 2025?
Yes.
Sarachandra Pradhan, Land National Standing Down is present. Pattern अच्छी आपको लगता है ये